people that might benefit from this, we can share the recording with them and get them the information that they need. So to start off, I'll just introduce myself and Executive Allies. So we provide fractional CFO and controller services for companies locally, really that just have a need for a higher level accounting, that don't quite have a need for a full-time person in that role. So that's us, and then I'll let each of these lovely panelists just share a little bit about what they do and how they're bringing value to the area of risk and safety.
Well, hello everyone, my name's Pam Howland and I'm an employment lawyer. So I've been practicing here in Boise about 25 years now, which is kind of crazy. And I started my own employment law firm in 2016, and all we do is we represent employers in the whole compliance arena. So you name it, whether it's claims, lawsuits, training, workplace investigations, all the counseling that goes with that. So, counseling questions are, for example, somebody calls and says an employee says they have a disability, they need an accommodation, how do I do that? That's an example of counseling. So we do that, and about 2 years ago, we really saw a need for employers to get more training. Again, with the litigation, after so many years of seeing the same mistakes like over and over and over, we decided that employers need more resources to avoid getting hauled in court altogether. So we started another entity called Law for Leaders, and that entity is solely to train and provide resources to employers to keep them out of court. So we have IEL, Idaho Employment Lawyers, and Law for Leaders, and we're always kind of trying to grow and change and bring things to the market that local employers need.
So good morning everyone, my name is Dusty Swinney. I'm the Chief Human Resources and Safety Officer for Western States Equipment. If you don't know us, we're a Caterpillar dealership just down the road. So I'm responsible for all things human resources, talent acquisition, talent development, safety. So I've got a whole team of safety professionals, obviously with what we do and working on equipment every day. We've got a huge risk factor for safety in our organization, and we have safety trainers and just focus on obviously lots of risk mitigation. And been in the business, I've been in Western States for 6 years now, but been in the construction industry in some way, shape, or form for quite some time, in different areas, but always kind of on that people side of risk mitigation.
Good morning, Carrie Purcell with Insure Idaho. We're a full service independent insurance agency, so we do auto and home, commercial, and we also do benefits, but I mostly just do commercial, medium to large commercial accounts, and for the past 10 years I've mostly focused on the construction industry. We just kind of like fell into it, so anything that goes into home building or home servicing. And I was just kind of talking about her a little bit too, but I really like to help. I like to help companies that are small and grow to bigger, and then if they're like growing too fast, we like help them get organized and make sure all their policies are like under one agency, one umbrella, stuff like that. So excited to answer some questions.
So when you have worked with companies and in your experience, where have you seen companies using planning to make sure that they can make a difference in job site safety or in the overall business protection?
Well, with employment law, it's really getting your house in order, making sure you've got a handbook, for example, and I know that sounds kind of boring. Like whenever we do training, we'll ask supervisors, okay, do you have your handbook? Have you read it? And frequently the answer is no, and sometimes employers will say, we know it's kind of just for show, but it's just this legal document. Well, the reality is it's so important, and if you don't have a handbook that's updated with the policies you need, you're shooting yourself in the foot for one of the easiest defenses you would have if you had a problem arise. So handbooks, policies, and then training. If you have employees, if you have supervisors, they're the ones who really need the extra level of training. If they're the boots on the ground interfacing with your workforce, your supervisors have to be able to spot issues. So, like ADA, for example, Americans with Disabilities Act, that's the #1 claim against employers all over the country, because that law is really hard to comply with. It's not intuitive. You can't just guess your way through it. And if your supervisors don't know that they have some obligations triggered if someone comes to them talking about a medical condition that's impacting their ability to do their work, it's really easy for that to turn into a claim. So the ADA is like the easiest example of that. Your supervisors have to have training so they can spot issues. It's all about issue spotting. It's all about knowing when to document things. You know, documentation, again, not a super exciting topic, but kind of like with handbook policies, you've got to know when to document things and what to document. And if you do that, the odds of you being able to defend against a claim or a problem, it's really high. That if you don't do that and you're not paying attention to it and your supervisors aren't trained, really easy to draw a claim on an easily avoidable issue.
Yeah, I totally agree. Actually, just sent through an ADA accommodations conference just yesterday. So the foundation is, you're absolutely right. For us, we're much further in our safety journey because we've got 5 states, we have 28 stores, we have 1,200 employees. And the biggest thing for us was changing our safety culture. And that's really the secret sauce, is focusing on the why behind safety. So what I've seen, what I see with other dealers, what I see with other companies is non-compliance just out of being lazy, quite frankly, right? We have a safety policy. Yep, you're supposed to rig up, right? You're supposed to put your harness on. You're supposed to use like your PPE. But #1, the companies don't enforce it, and #2, the leaders they're not role models, right? And so we had to turn around our safety culture. And we had a great safety culture for a really long time, and we were stuck at a high OSHA reportable level compared to other cat dealers. So we were if we could rank them, we were kind of one of the bottom for a while. But we're like, it was all small things. It was like cuts that required stitches. It wasn't big things. So we had a fantastic safety culture, and everybody bought into it. But we're like, how do we turn this ship around? And so I think 3 things were essential. 1, it was support from our executive team and going out and saying that we support safety and that we're engaged in safety. But 2, we started really focusing on the why, and that's everything. So we do a lot of different programs and exercises regarding the why behind it, which is typically your friends and your family. And then the other thing was just really turning to focusing on proactive leading indicators. That was the big thing. So, for example, we do peer-to-peer observations where somebody will do an observation, but we'll tag them as wins. So that's the big thing, is focusing on those kind of positive things. And that has completely turned everything around. And when I pull the data, 100% of the time, there's a direct correlation, inverse correlation between when your leading indicators are high, which would be safety toolbox talks, safety meetings, doing those peer-to-peer observations. We have employees submit concerns and then mitigate the risk. How do they mitigate it? We do a lot of really kind of fun, super corny programs, which have taken hold, called Gator Bite sightings and Sasquatch sightings and all kinds of things like that. But our injuries have gone down, and the last 5 years in a row, we've had the lowest OSHA recordable rate. We keep beating it in terms of wins that we've had in company history. So I think, you have to have a no tolerance for non-compliance. You've got to have all the policies and procedures, but really, to be effective, you have to focus on those whys and have a positive safety culture that focuses on that gets people to think, at the end of the day, if I'm about to put my hand right here, and there's a risk to do it, I need to stop and think. And how do you get them to stop and think and do something differently, because they're in a rush, they're going to take a shortcut, and okay, stop, what am I going to do differently today? And what's amazing too is that we've been effective at is people have started being in compliance with those safety things at home and taking it home. So we also involve the families. So we do a lot of things that like kids safety coloring contests and things like that that involve the families. And it's really cool. And then you have a new employee and they've been part of a different safety culture, and they come here and they're like, oh my gosh, this is really cool. And I just started thinking about, I'm now wearing ear protection when I mow the lawn, and I'm now wearing boots when I mow the lawn, and before I was out of my flip-flops and no eye protection and no ear protection. And you're like, that's kind of cool, right? Totally to changing the mindset.
So in my industry, we always just recommend asking your agent or your carrier if there's any resources. So pretty much every carrier that we work with, they have safety consultants that can come out if you ask them to regarding your work comp. So and the agent can come out as well. So it's usually like at renewal we can come out and sit down with you, and they'll like say we can go to job sites, we can help you with anything, any recommendations, stuff like that. I have a story actually. I did that with a large roofing contractor, and we went out, we did the renewal, and they were like, yep, just make sure this, and this. Well, sure enough, a couple weeks later, OSHA did a random inspection on them, and everyone was up there tied down, and they passed with flying colors. But it just like gives an example of, like, if you do it and you put in the work, you're not really like threatening your employees to like do it, but they did start implementing a policy of like, yep, you get one warning, and then if we get an OSHA violation, then we're passing that on to you, you as the employee. So it kind of like incentivizes them to also like wear all their PPE and safety equipment. But yeah, just ask your agent, ask your carrier if there's any resources. They're all free and they're available to you. You just kind of have to ask and like know to ask and use them.
So Dusty, you talked a lot about the culture of having a culture of safety. Can you share a little bit more about what that looks like tactically, and how maybe a small business could implement something like that, where it's starting with that culture of safety? And what would you recommend there?
Yeah, like was mentioned earlier, you've got to have your safety policies in place, and you have to make sure your employees read those and understand those. Those are the price of entry. But beyond that, I think engaging in the safety talks every single morning before you start a job, that is essential because it gets you focused on the day. I imagine most people are experiencing this, but I know we're experiencing more mental distractions than ever before. There's so many people struggling with the stress of life, the stress of their finances, all kinds of things, and what happens is just lack of focus. And so, you're doing a job and you start your mind wandering. But if you start the day talking about safety, but you have to do it in a way that is people are engaged in it, not just like, are you wearing your PPE? Like, you have to have it where it's kind of positive and motivating. And then I think that the other thing that is important and very, very effective for us is we do a job hazard analysis. And our technicians are required to do that every single time they change a job during the day. So if they're working on this excavator, they have to do a JHA for that excavator, and then they move over to a skid steer, they've got to do a JHA for that. And what that looks like, it's just a paper assessment in our particular case, but they're talking and identifying all of the hazards and how they're going to mitigate that risk. And again, it just keeps them in that mindset, because otherwise you just go too fast. And it is interesting too, we did a study a couple of years ago, and we pulled all of our injuries and then did an assessment of how many times those injuries they were associated with a job that did not have a JHA, and it was like 80 or 90% of those injuries did not have a JHA. So something so simple as just making them focus, fill out the JHA, or even talk about it. And so a lot of times now we've got to the point where if somebody walks out, this happened the other day, that there was a machine that was jacked up and somebody had walked out. It was a new technician, and the technician didn't have the jacks correct, and another tech saw that. Well, now we have a culture where they say something. So they're like, okay, let's stop work, everybody stop, we're gonna have a stand down, we're gonna research this, we're gonna figure out how to do something safely, and having those conversations throughout the day. But I think that part is critical, just like you said, in terms of tactical, just that focus and that awareness, because that's what we see when injuries happen. We had one happen, it was actually what I would call a near miss, but they were testing a machine, and so it had hydraulic pressure, and so they had to pressurize it. He decided that he was going to go, we were doing a summer safety event where people were giving out popsicles because it was really hot, So he went to get a popsicle, came back, totally just forgot, started unscrewing the screws. And one of the screws flew past his head, and then he realized what had happened. So nothing actually happened, but it was that mental distraction that is the biggest thing. So that awareness, whether it's toolbox talk, whether it's a job hazard analysis, whether it's we try to say the culture of care, that if we notice somebody doing something wrong, fortunately, we've gotten past that initial when you're trying to change that culture. Initially, it's met with like, who are you to tell me what the hell to do, right? Don't tell me what to do, that kind of thing. But when you're able to change it around to like, hey, this is a culture of care. I don't want to see you getting hurt. I noticed this. Can we talk about it? That has been instrumental in reducing the injuries in Western states.
And Pam and Carrie, as you work with some smaller businesses, because that's the primary area where you both work, what do you see being resources available to small businesses that they can use? Carrie, you had mentioned the safety agents that can go out and meet with them. But Pam, what about you? What do you see businesses that you work with doing to implement these job safety tactics?
Well, again, I think it's going to go back to training and education, and in the employment law arena, like understanding implications like that. There's a lot of free resources out there. Like it could be, understanding best practices through the Society of Human Resource Managers. That is an easy membership. It probably costs like a couple $100, and they'll shoot you emails, like multiple emails a week with the cutting edge employment law issues that are out there. As Dusty was talking, what I was thinking about safety is we have some bigger clients who have called us in to do workplace investigations regarding safety issues. And everything you were saying was really resonating with me, because I feel like the really solid safety programs have mechanisms in place to show the workforce, we're going to take this serious, and if somebody brings a complaint, it's immediately investigated thoroughly and completely, and employees know they aren't going to be retaliated against for slowing things down. They're not going to be disciplined or punished, and that those policies are going to be enforced. So thinking through, what that safety culture looks like, and you were talking about your daily meetings, just that focus and mechanisms and policies, and really talking the talk that goes with it, so that if anything comes up, like those examples you gave, employees get the message, okay, we know that that's going to be taken seriously, and that's going to be enforced, and that we aren't going to be penalized for bringing something forward.
Can I give an example?
Yeah, I have an example of that, so it might help to resonate with what you just said. So we had a complaint against us to OSHA, saying that we fired someone for being a whistleblower for bringing forward a safety concern. But what actually happened is we have a very strict requirement that if anyone has an incident, and doesn't even have to be that they've got a cut, they got an injury, if they just felt a tweak, they felt a pull, anything like that, we require them, and they know this, and they sign it, and we talk about it all the time, that they have to record that within 1 hour of the event if they're on site, or 3 hours off site. So we had a gentleman slip and fall off of a trailer, just barely kind of tweaked his leg in the snow. And he didn't report it. At the end of the day, his supervisor, ironically enough, just happened to call and see how the job was. He didn't say anything about being injured, and then I don't remember, like a week later said, hey, remember that job? I tweaked my knee, now it's a workers' comp injury, and so on and so forth. Well, throughout the entire investigation, we ended up firing him because A, he didn't report the event within 1 hour, but 2, he falsified his JHA because he had said that he knew about our ice cleat policy. He had put in his JHA that ice cleats were a preventative measure, but we actually had his original JHA, that he didn't know we had his original JHA, and then after he made the complaint, he changed his JHA to identify the ice cleats. So we fired him for violation of our company value of integrity. We then got the whistleblower complaint, And he said, you fired me for reporting a safety incident. And then I was able to show all of our policies, all of our procedures, how we have a culture of mandatory reporting. And we celebrate that reporting, and we talk about the safety wins all of the time. And then I was able to say also, here's how many people I terminated for violation of our company values last year. So it is absolutely in line. And so totally having those policies, just to your point, absolutely got us, the complaint was dismissed and he went on his way.
And so so talking about whistleblowing, not speaking my language, just me. But, okay, so along those lines, another mistake small businesses make is they don't have an investigating mechanism, right? Like if you're running from job site to job site, trying to get things done, you don't have many employees, if somebody comes to you and says, I have a problem, here's what it is, it might be safety, it might be harassment, it could be any of the employment law things. What's really important for small businesses is they have someone who can investigate those things, and if they don't, they know an outside source to call who can come in and do it. Just so, I think for safety, the biggest mistake would be not investigating it, and I get it, for small businesses, sometimes that's because you just don't have enough resources. That's not gonna cut it though. You gotta have in-house or outside third parties. In my world, we work all the time with HR professionals. So there's a lot of HR professionals who can chase something like that down. And I imagine there's a lot of other resources in the safety arena for people who could investigate if there's a problem or a complaint that comes in.
Yeah, absolutely.
Carrie, what about you?
Well, I was just gonna kind of tag along, one of the biggest mistakes that we see in the work comp world is not reporting claims timely. So, I already kind of gave her this example, but I'll say it again to you guys. So let's just say someone has a cut. Well, okay, not reporting it timely, and then also trying to pay for the claim yourself because you think that it's minor, and I don't want to make more claims on the work comp. So the example that I always give is if it's a cut on your finger, and they're okay, yeah, let's go and get a couple stitches. Well, said cut can get infected. Well then, what if the finger has to get amputated, stuff like that? So now you're on the hook as the employer because you didn't file the claim, and if you try to file it, they're well, where'd they go to the doctor? You didn't file it, and so the responsibility and the liability can end up falling on you. And so I don't care how big or how small the claim is, we 100% of the time recommend using your work comp policy. That's what it's there for. Work comp carriers know that there's gonna be claims. Just trying to mitigate them. And then the other thing too is not being proactive and being reactive. If you're seeing a lot of claims frequency, not getting on top of that. Why are we having so many cuts? Why are we having 17 back strains in the last year? And then because the frequency of claims and then the larger the claims, your EMOD, I don't know if you guys are familiar with an EMOD and work comp is just how many claims and how large of claims you have. The higher the EMOD, the higher your work comp rate is going to be. And so if you can be proactive and stay on top of gloves or back braces or whatever it is that your employees need that maybe they're not using right now, we can help keep that EMOD down. That's really going to help with your rates. So those are some of my.
I had a perfect example of that very thing. So we were seeing a lot of hand injuries, cuts resulting in stitches. And we started investigating it, and we realized that the common denominator was nitrile gloves, because we work in a lot of oil. And so what was happening is, they weren't wearing their cut-resistant gloves, because we found out that they were too uncomfortable, they didn't have a lot of dexterity, things like that. So we had gotten the cut-resistant gloves, but we're still getting the injuries. And so what we realized would happen is they would take their cut-resistant gloves, their nitrile gloves were below, but they would have a false sense of security that they had their cut-resistant gloves on because they had their nitrile gloves, and then those obviously have no protection. We actually ended up taking away the use of nitrile gloves and then getting some oil-resistant gloves and doing a big whole project. And we went from that being our biggest injury to the next year having 0 cuts related to that. But it was like you said, we started seeing the trend, investigating it, and it was hard. I mean, to this day, people get frustrated that, it's everybody has a different preference with the gloves, and they don't want to use their gloves because of dexterity things. But we just have zero acceptable tolerance for not having the cut-resistant gloves on.
Another thing I'll add too is if you do have that and your EMOD does get high, and let's say like your work comp carrier is like, oh, we're not gonna write you anymore. There are carriers out there. If you're willing as the business owner or the HR manager or whoever it is to work with the company, be like, here's the steps we're gonna take, voice that to your agent or the other carriers that are looking at like quoting you, because if you're willing to work with them, they're willing to work with you. And then it'll be that much easier to like get a policy, and then 3 years down the road, you know, your EMOD will start to come down. You'll see the rates come down. But yeah, just honestly be open and transparent with your agent and be like, okay, I'm willing to, you know, I'm willing to work, I'm willing to do this stuff. And as long as you're proactive in everything, carriers and agents will work with you.
2 mics is always fun to work with. Okay, so Carrie, now we've talked a lot about mitigating risk. So these accidents do happen, and so can you walk us through what it looks like to file a claim, and then what that whole process looks like and what to expect?
Yeah, so every company is probably different, whether you have a 1 hour reporting period. I always at least recommend same day. So telling your manager, your boss, the owner, whoever it is, same day. And like I said, for liability reasons and ease of process. So usually you can call it into the carrier, call it into your agent, but there's a lot of information that you need to have that a lot of times like the agent doesn't have, like social security number, date of hire, hourly rate, like that. So always ask your agent for a claim form, and you can just keep it on hand. And so when there is a claim, you can do that, and then you can turn it into your agent, or you can turn it into the carrier. And then if someone went to a doctor or they went to the hospital, whatever, if you have a claim number within 24 hours or as soon as possible, it's a lot easier to get paid. So then your employee's not getting invoices or getting, you know, bills. It's already going through the work comp carrier. So that's like what I would recommend as far as like filing as soon as possible, and then also reiterating, don't just assume the liability yourself and just tell the employee that you'll pay for it.
On that same topic, what would employers expect if they do have claims to mitigate that the fear of having your rate go up? What does that look like, and what should employers expect to see?
Yeah, so like I said, work comp carriers know that there's always going to be claims. It's the one policy where there's just always claims on your policy. And what I always hear from my carriers is make the claim, that's what we're there for. And then if we need to, at renewal, start implementing some more safety things or come out and look at it. But don't be afraid to make the claim. That's what I always say. Because it's gonna take a long time. Because, let's say your premium is $50,000. If you're having a lot of claims that are $50,000 or above, then yes, the carrier is gonna be like really worried, like, okay, we're losing a lot of money here, like what's going on? But if you have a $50,000 policy and let's say you have like a $10,000 claim and a $2,700 claim or something like that, they're really not gonna bat an eye. You know, it's just like, okay, this is like the expectancy that we were seeing for this premium range type of account. And yeah, just don't be worried to like make the claim. I always like protect your business by making the claim versus not making the claim. That's honestly the number one way you can protect yourself with work comp is to make the claim. Because at the end of the day, like you can always find a policy, even if let's say they do cancel you, there's always gonna be a policy that there's carriers that have to write you if like they're the last resort. So just don't be afraid of the rate. And like I said, if you are willing to implement safety things down the road, then carriers we've seen, okay, they're gonna do that, we'll discount it a little bit, you know, instead of a lot, like a little bit to offset some of your EMOD rate increases, stuff like that. So there's lots of options, but yeah, just don't be afraid to make the claim.
So we've talked a lot about job site safety. Now, people can, or what we see is companies can kind of write off the benefit of workers' comp when you don't work in really, you know, high danger type of employment. So what do you recommend for companies that maybe have a mix of construction workers or people in the field and office? Pam, what do you see from a policy standpoint that companies should have in their employee manual to make sure all of those roles are covered?
Well, I'm not sure if this goes to the question exactly, but it's an important point that was coming to mind as Carrie was talking, which is when we're talking safety, one thing we've seen in the manufacturing and construction industry that gets missed by employers is, okay, you've got workers' comp, but what if somebody gets injured in the workplace, say that's a back injury, something fairly major. What employers frequently don't think about is how ADA may be implicated by that as well. And so sometimes we see employers without an Americans with Disabilities Act policy. Again, that's the #1 claim against employers all over the country. And it's just frequently overlooked by employers. So here's an example of that. We had a client who had an employee who got injured on the job with a back injury. So they call workers' comp. They get everything lined up. They've got the workers' comp coverage, but it's a serious injury. So it spans multiple years because the employee comes back and is trying to work through this injury, needs some light duty type stuff, eventually has to go out on leave because they need a surgery. All that is ADA land. And the employer didn't really have any ADA training, didn't realize that would be potentially a covered disability, that they needed to be talking about accommodations. And what we also see sometimes is when employers have workers' comp triggered, they just they start working with the workers' comp agent, and they just assume that if there's a problem that would trigger a Disabilities Act issue, that the workers' comp carrier's thinking about it. Well, they're not, because that's not what the workers' comp carrier does. They're thinking workers' compensation compliance, its own set of laws. They're not thinking about how they're gonna handle their obligations under the ADA. So, again, go back to that client we had, they got sued for disability discrimination because they weren't considering what type of obligations were triggered under that act. If you really want to complicate it, then throw in Family Medical Leave Act coverage. If you're a big employer, I mean, I call it big, 50 or more, that's big in my world. So if you've got that at issue too, you've got 3 separate statutory frameworks, all with different obligations. And if you're an employer and you're not thinking about that, you can trigger liability under multiple statutes. In Idaho, 5 employees or more triggers Americans with Disabilities Act protections. That's not many employees, right? I'm guessing most people, if you're here, would have 5 or more. So that's one example of different policies, different protocols, different procedures that are all related but are all kind of separate, and that you need training to be thinking through those.
Can I piggyback on something? Okay, so probably a common misconception with workers' compensation insurance is if you ever see on your policy there's limits. The state is 100,000, 500,000 is the state minimum, and you can go usually up to $1 million, sometimes higher. So work comp, there really isn't a limit if someone gets hurt, right? Like we've had someone get in an accident, paraplegic, they paid out a couple $1 million. But where the employer's liability portion comes in is if there's someone gets injured and they said, well, my employee didn't provide me such and such, is when the employee can sue their employer, and that's where the employer's liability portion comes in, and that is really, really crucial. We don't see a lot of those claims, but it is there if in the event that the employee tries to come after the employer. And so that's where I always recommend raising your limits from the 100,000, 500,000 to 1 million if you can, because as you probably know, the pricing is so small to increase it, but the coverage is exponential. So not that no one's not supplying like the right equipment, but in the event that happens, so that's the difference in those coverages that you see on your policy. The work comp doesn't actually limit the 100,000 if someone gets injured. That's for the employer liability part. Does that make sense? But yeah, that would kind of go back to like what you were saying with ADA type stuff. And like I said, so I did an event with one of my work comp carriers, WCF. We volunteered together, And I was asking them, hey, how many of these employer liability claims have you guys ever seen? And they said like 5 total in 20 years. So it kind of gives you an idea. But it's there, and I think that it probably is going to start happening more because everyone is so happy these days, and they're always, trying to blame someone else. So, yeah, just keep an eye on those limits, and if you have any questions, contact your agent and stuff like that to ask about limits.
Okay, so this transitions kind of into more of the workforce risk on a different perspective. So when we have businesses, tough issues come up. Things like substance use, discipline. What do you recommend for a best practice when it comes to those two areas?
It's a really easy question. Not actually. I think that question of drug use and alcohol use, any type of impairment on the job, I think that's the most difficult question for employers to answer, especially under the Americans with Disabilities Act. Because what we know is that, go to like a construction industry example, you're probably going to have your safety policies. You're probably going to have, hopefully, you've got a good handbook that's got a drug and alcohol testing prohibition, lays out that in the code of conduct. If you don't, you absolutely need it. But the practical reality is, what do you do if you're an employer and somebody comes to work and tells you, I think Joe, I think he's impaired. I mean, that is a difficult, just practical thing for employers to deal with. Does that trigger your drug and alcohol policy? Probably, but people are always afraid to pull the trigger on it because that's a tough discussion to have. Are you gonna go up to Joe and say, look at me, do you look impaired? What are the facts that show someone's impaired? It's kind of a big allegation to make. So what we see happen is, unless you've got supervisors trained who know what your policy is, who know exactly what the approach should be, a lot of times they ignore it because it's uncomfortable and they think, I don't know if we have enough evidence that, what if he's not? What if he's just tired? We see people who just don't act, and that's a huge problem because if you don't act, the issue potentially goes away. Or maybe it goes away for a couple days and then it comes back, but all that stuff is so time sensitive under your drug and alcohol testing policy that if your supervisors don't know, if they're not trained, they don't know what to do. So under the ADA, so you've got your drug testing policy, that's one piece of the puzzle. Under the ADA, for example, prescription drug use might be covered. Again, go back to the example of the employee who got injured, who had the back injury. They were taking oxycodone, for example, because they had this really serious surgery. Under the ADA, prescription drug addiction can be covered. So if you're an employer, is that flagging to you, geez, maybe I better think through if there's an ADA issue here too. Same with alcohol. Obviously if somebody shows up on the workplace impaired because of alcohol, that's probably not going to be a protected anything. But what if, go back to the example where the supervisor doesn't do anything about it, and then the next day the employee comes in and says, I gotta tell you, I'm really struggling, I have this alcohol issue, but I'm getting treatment, I would consider myself recovered. Okay, that would be covered under the ADA. So, best practices, good question. I don't have a roadmap for you to follow. To me, all the drug and alcohol issues are so confusing and so fact specific. I'd say call for counsel on that one. Drugs and alcohol, make sure you've got the right policies, you've talked about it internally, and if a problem comes up, call counsel and walk through it and come up with a plan. Because if you don't, you got potential liability on a bunch of fronts. I don't want to dominate the conversation, but we had a case about 8 years ago that involved a law enforcement officer who showed up to the workplace under the influence of they're pretty sure it was oxycodone because he'd had surgery. He was just coming off a major surgery. They didn't test him, but they sent him home for, in the law enforcement world and in construction, this could potentially come into play too, this whole fitness for duty concept. They had a fitness for duty policy, they sent him home and they said, we need you to go see a doctor who's trained on these issues, who can tell us whether or not you're really fit to do the job you're hired to perform. And the cop went and his doctor did not pass him, and while he was on leave, because then they're like, well, we can't bring you back till you can pass the fitness for duty, he got a DUI, and so they fired him, because you can't really be a cop with a felony, right? And this was a high level law enforcement guy. That ended up resulting in a disability discrimination claim that took 8 years to resolve. One of the arguments that the law enforcement officer's attorney made was they never tested him. How would they be able to prove? He didn't have a problem, that's what they argued. He didn't have any problem. They just made these assumptions and they never triggered their drug and alcohol testing policy, so they can't prove it one way or another. That got a lot of traction in front of the court. Just to really complicate it and to show you how difficult these are, what we know though is most drug and alcohol policies probably wouldn't flag a prescribed drug as violating the policy. So it was this impossible no-win position. I don't have a great protocol for you to follow, but it just goes back to your supervisors need to be trained that drug and alcohol situations are urgent. You've got to have the right policies. Everybody internally needs to be on the same page as to a general testing framework. And if you have one of these complicated issues come up, call for counsel.
I think too, it could have been in the absolute best interest for them to have reported a sensitive attorney instead of the same one, because ultimately he made worse choices down the road. Might have gotten
Yeah, well, just to continue on that thought, that case was so crazy. Again, 8 years. So it goes to trial. They won at trial. The law enforcement officer won at trial, but then there was a mistrial because his attorney engaged in misconduct. He put on a witness who lied and never flagged it. While the mistrial proceedings were going on, the law enforcement officer overdosed. He didn't die, but to your point, there was a huge issue, but proving that's really an issue is very difficult for employers to do. That's a crazy case.
The only thing that I have on drug and alcohol stuff is if you do have a drug and alcohol policy, let your agent know there is a discount on your work comp. It's usually 5%, so not a lot, but if your premiums are higher, it can make a difference. And they do really value that you have a policy and that your supervisors know your policy. So if they do see someone, they can report it right away, so it doesn't turn into a big issue. So it is a discount you can see on your work comp policy.
Yeah, I echo, it is so complicated these days, but I think you made a lot of good points. That one, understand reasonable suspicion so that you train all your supervisors or leaders wherever you're the one. Make sure you understand what reasonable suspicion is so that you can prove why you sent some to test someone. To test them. So I had a situation, not with the company I'm with now, but a while ago in the state of Oregon. We currently here at Western, we do operate in Washington and Oregon. We've got medical marijuana or even just legalized marijuana use. So different company. A director of the facility walked by the men's bathroom. The guy came out, marijuana smoke going crazy. She's like, hey, were you smoking in the bathroom? He's like, yeah, man. She fired him. Didn't turn into a claim, but he did get approved for unemployment because we didn't test it. Even though he admitted to what he did, and it was visual, proof of it to there. And anytime you're getting those unemployment claims paid, then you're increasing the rates that you're paying. So that's a big thing. And then lastly, I just say know your state laws, because it's so complicated, particularly when you're in a state that allows medical marijuana, because then they say, well, I know you smelt it, which is part of the reasonable suspicion, but it's just because somebody at home was smoking, right, and that's perfectly legal. And we're in a state too where you can't even test for THC in creative limits. So there's all kinds of different laws. You have to know them if you're in different states, or where's the line cross in all the different situations.
We've had a couple large accounts with a lot of employees, and they've kind of like not really contracted with primary health, but they've like advised their employees if they get injured to go to a primary health, and the reason why is that primary health notes like on their account if they come in for an injury, test them, and so then that way they're always being tested, and maybe the injury was caused because they were impaired or something like that. And so it may not apply to super small companies, but if you do have a lot of employees, it is something to like keep in mind that I do know that places like primary care can do stuff like that, so that they're always testing.
Man, I know for me, even I don't have a workforce in the construction field, but all of this stuff has been super valuable. Okay, so tying this all together, how do we have legal, insurance, and our safety HR team? How do we have them all work together? And how do we take home something today that we can implement in our business to improve our risk and safety?
Well, speaking of something you could take home today, so we wrote a book about this. We actually have some books if anybody's interested in buying books, but there's resources out there. I mean, and again, I think it all goes back to training. Like I think training, communication, collaboration, proactive measures. It all starts with the boring stuff, policies, right? And then you gotta roll it out and make sure everybody's following it. I think collaboration with Carrie's example, your workers' comp carrier, like sometimes we'll get calls from employers and they're like, look, I have someone who was injured, they're on workers' comp, but they're here, they're doing light duty, they're just a terrible performer. Can we fire them? I mean, my advice in that's always gonna be keep the carrier in the loop, because the carrier's got the goal of bringing the employee back, right? And terminating the employment's gonna impact the carrier. So, making sure that the different people who have a stake in the outcome are involved is a huge piece of the puzzle. HR is a huge, in my mind, like if you're a sizable employer, you've gotta have a good HR presence, and your HR people need to be respected, and they need to be trained, and they need to know how to roll all this out to everyone else. Again, go back to the SHRM example. Good HR people are watching stuff like SHRM input and stuff coming out from the EEOC, and the leadership team is listening to them and rolling it out to everyone. But I think the biggest thing employers don't do is they just think, well, we're kind of small, we're not going to worry about it till we have a problem. And the average cost of a jury verdict in Idaho right now on the employment law front, $1 million. So it does not make sense to ignore these things until they turn into a claim or a lawsuit. Some proactive measures can avoid everything altogether. So, no reason to put this off. And again, proactive training, policies, documents, that's the type of stuff you need to be thinking about.
Yeah, I agree. If you can't afford an HR team because you're small and you just had your growing company, there's a lot of HR consultants out there. So you can hire them just to come in and create your policies and procedures, or to be on call when you have a question. My kids work for small companies, and I just I cringe when they come home and tell me. I'm like, that is so illegal. And they're great companies, right? And they're good people. They just don't know. It's not like egregiously illegal things. It's just things that they literally don't know. But that, that consultant, that HR consultant is worth its weight. And then, going back to the safety front, I think just having no tolerance for safety violations is absolutely critical. But then to the extent that you can have a positive safety culture and focus on the whys, you will 100% reduce your injuries when people are doing it for the right reason versus compliance. Because when it's for compliance, they are going to take a shortcut. They're going to be non-compliant when they're in a rush or whatever, when they have that mental lapse. But if you can focus on that proactive safety and keeping it in front of them every day, you will absolutely mitigate a lot of your risk.
Yeah, I mean, we see it all the time, growing pains, right? So you don't know what you don't know. Like, you don't know if it's illegal. You don't know that you're supposed to have an employee handbook. I joke with her all the time. The amount of companies I see that don't have an employee handbook honestly kind of blows my mind. But as you do scale, I just ask questions. Like, we're all here. Or do you have a recommendation for this? Or do you know anyone for that? Like, if you know, the person you're talking to doesn't know, or ask your agent. But you're building a business and we want to help you protect it. Like, that's our goal too, you know, at the end of the day. Like, we care about your business just as much as you do. And so, yeah, just ask. I mean, like, there's no stupid question, you know, like, and if you think it's stupid, just ask it anyways. Because if it's going to be helping protect you, grow, and protect your business, then it's going to be a good question, in my opinion. So, yeah.
Unfortunately, ignorance is not a viable legal defense, right?
Right, unfortunately.
Yeah.
And sometimes you have to go through things to learn. Like, man, I didn't even know that I had to have a reporting policy or something, and you learn the hard way or whatever. But every small business doesn't know that at the beginning, and they'll probably all have to learn some way too. So.
Well, I love what you brought up, Carrie, about having a network of resources that can help you. And so even in this room, BBSI is a company that you can work with that can help with the HR. But knowing where to look or who to ask, and so having great resources like any of you on this panel is a really good option. So right now, are there any questions from the audience that we didn't answer that you hoped we would answer? Everybody has an appointment.
I
David?
have one question. Hey, Dustin, you mentioned you're not allowed to THC testing or drug, and again, I don't know. I get this, I was just shocked by this. You're not allowed to do THC testing in a foreign, right? But if you have a policy of random drug testing, is that allowed then, or what?
Yeah, that's not in the state of Idaho, by the way.
Okay.
It's a different state that we're operating in, so
Okay.
you totally can do that in the state of Idaho.
Okay.
But even in the states that allow like medical marijuana use or may have marijuana use policies, as a company, you can still have no tolerance policy. They cannot be under the influence within your organization, and that's what we just hold true to. So sometimes you could spit you, even though we can't pre-employment test them in that particular state, we can do post-accident testing and hold them accountable for being under the influence. But that's not Idaho, so yeah.
Anyway, thank you for the clarification.
Yeah, it's very confusing and complicated.
You do a lot of subcontract, how a lot of subcontractors, a lot of different community is the best. You know, my policies for my employees are different than subcontract. So, I guess the best way, because I have had a subcontractor who has had some drug and alcohol use on the job site, and so just for a subcontracting standpoint, it's just having language in my subcontracting out the policy of what goes on, so it'll be enough.
I'm just gonna repeat that really quick so we get it on the video. The question is, when a contractor has subcontractors that work on the job, what are the policies that apply to the subcontractors, and how does that interact with the policies of the general contractor versus the subcontractor?
Yeah, my reaction to that is you're spot on. It's gotta be in your subcontract agreement because you can't hold them to your policies or then they start to look like an employee. So that's always the fine line employers are trying to walk is how can I have third parties who aren't employees when they meet the criteria, and what do I need to do to avoid making them look like they are? And that handbook piece would be one. So I think it would be very carefully worded language in your subcontract agreement that maybe has language that looks like your policy, but it's not in any way holding them to your policies.
I mean, yeah, so we do a lot with GCs that have a lot of subs, right? And I that's actually a good point that I've never even thought of to recommend. So, because our insurance carriers, they only accept certain sub-agreements, right? So they are required to have their own GL and their own work comp and their own auto insurance and all of the above and umbrella. But I've never thought to recommend, hey, add a drug and alcohol component to the sub-agreement. So I'm gonna take that back with me today. So that's a really good, awesome question.